Okay, so thank you for this introduction, Magdalena, and for the invitation for today's seminar. And let me also introduce a little bit of Association for Legal Intervention. Association has been working in the asylum area since 2005. We have been providing legal assistance to asylum seekers, migrants, stateless persons, refugees, essentially third country nationals staying in Poland, both before national authorities, but more recently also before the European Court of Human Rights. And as we focused mostly on Articles 3, 5, and 13 of the Convention in the recent years, in 2021, Article 2 has been very brutally entered into our everyday work. Since August 2021, the humanitarian crisis at the Polish-Belarusian border continues, and many third country nationals are actually put in life-threatening situations at this border. As we know, until today, at least 37 people died at this border. And as pushbacks in human treatment at the borders, death at the borders is something new in Poland. In Europe, it is nothing new, and we can see that very clearly from the jurisprudence of the European Court of Human Rights concerning Article 2. So today I will be speaking about first, positive obligations under Article 2 in a situation when a migrant dies at the borders of the European countries. Then we will move to the protection of life in the detention facilities as well as reception facilities. And we will finish with the matter briefly introduced by Professor Turkowicz concerning the principle of non-refoulement and the applicability of Article 2 in this context. So let's start with 3 cases concerning pushbacks at the European borders, one concerning Croatia, one concerning Greece, and one concerning Hungary, the most recent one. And of course, we have to start with MH and others versus Croatia. That's a well-known case from 2021 where a child died in Serbia, actually, hit by a train. The family of the child claimed that they were pushed back from Croatia, and when they crossed the border to Serbia, then the accident has happened. The Croatian authorities, of course, claimed that the family never entered Croatia before the accident. They just entered Croatia after the accident with the child, injured child in their hands, begging for help for medical assistance. The applicants complained in that case that Croatia had been responsible for the death of the child, and that the criminal investigation concerning her death was not sufficient from the standpoint of Article 2. First, the court took a look on the investigation that followed the accident, and noticed that actually the national authorities focused a lot on the fact that police officers made very concurring statements with regard to this situation, while there were differences in the statements of the applicants. The court analyzed those statements and concluded that actually there were differences in the police officers' statements, and also suggested that the differences in the applicant's statements would be a reason of bad translation. Nobody on a national level looked into that during the proceedings. Moreover, there was no physical evidence in this case, despite the fact that the applicants applied for GPS data to be extracted. This motion has been ignored. There were cameras at the border that were working on the day, but they were not storing images. At least this is what was said to the criminal investigation. Nobody also checked whether that was true and why they were not working. Also, the statement of the Serbian authorities was ignored in the criminal proceedings. Serbia said that Croatia violated readmission agreement in this case, and it was not taken into account in the criminal proceedings. Also, the applicants had hampered access to legal assistance. Their lawyer was not informed about the first interview. The one when all the contradictions occurred, and also she had no possibility to meet with the applicants until something like 1.5 months. After a very long time. The court also noticed that the family was Afghan nationals. They had no knowledge of Croatian language. They didn't know legal system therein, and also they had no contacts in Croatia, so they could not be expected to know how to act within criminal proceedings in Croatia. So for all those reasons, the court concluded that Croatian authorities failed to conduct an effective investigation into the circumstances leading to the child's death, which is in violation of Article 2 of the Convention, its procedural limit. Unfortunately, the court did not examine substantive limit of Article 2, so did not answer the question whether Croatia was responsible for the death of this child. Simply because they had not enough material available that would put the court in a position to reach any definitive findings in this case. So let's move to Safi and others versus Greece, very important case from last year, which for some unknown reasons is available still only in French. But the case concerns the event of sinking of a boat at the sea. There were 27 migrants on board, and 11 of them unfortunately drowned. The boat was intercepted at the sea by the Greek Coast Guard with some involvement of the Frontex, Greek Coast Guard decided to tow it back to Turkey. In the process of doing that, the boat capsized, the migrants went into water, and 11 of them did not survive. The applicants complained that as a result of the acts and or omissions of the Coast Guard, Greek Coast Guard, their lives were endangered and their relatives died. They also complained on degrading treatment upon disembarking. Again, the court started its assessment from the procedural point of view, and again noticed translation problems. During the first interview, there were some serious, let's say, translation problems, which were very soon noticed by the applicants and very soon pointed out to the national authorities. However, those incoherences of version of events were not actually investigated by the national authorities. Conversely, they used the incoherences that occurred in those first statements and following statements of the migrants against the applicants. Some evidence motions were ignored that, according to the European Court of Human Rights, were important to follow, and also necessary lines of investigations were not pursued. For example, the prosecutor in deciding on the case indicated that there is no practice of towing boats back to Turkey in Greece, while the Greek government openly stated that such practice exists. Taking that into account, the court concluded that, again, Article 2, procedural limb, has been violated in this case. But conversely to the MH and others case, here also the violation of our substantive limb of Article 2 has been found. Here the Greek government tried to argue, we can say blame the migrants for the dangerous situation they were in, because the Greek government said that migrants themselves, they taken a boat that was unsafe, overcrowded. It was a very bad day to go for this kind of journey. The weather was very bad, so migrants themselves put their lives at risk. The European Court of Human Rights turned this argument around and said, if it was so obvious from the very beginning, then it should be obvious for the Greek Coast Guard that it is dangerous to tow back the boat back to Turkey in those circumstances. Moreover, the boat of the Coast Guard was actually not suitable to conduct any rescue operations. Despite that, no reinforcements were called for. The migrants were not given life jackets. What's even more, Greek government tried to argue that the boat capsized because the migrants panicked. So again, it's their fault somehow. The court said, even if it was a reason for capsizing, then the panic of migrants was understandable, because the Greek Coast Guard decided to tow, to continue the towing back the boat, despite some destruction of the boat happening in the process. So the panic of migrants was understandable. What was not understandable, according to the court, was why they continued to tow back destroyed boat. Also, the court noticed that rescue centers were informed with a delay, and when we are talking about rescuing people from drowning, any minute counts. So in conclusion, the court said that the Greek authorities did not do all that could reasonably be expected of them to provide the applicants and their relatives with the level of protection that is required under Article 2. And violation of its substantive limb has been found. Lastly, in this judgment, the court approached the issue of strip search. So the survivors of this accident have been taken to the basketball court in open air, and they were forced to be subject to a strip search altogether. It happened just upon the shipwreck and upon the situation where many of those subjected to the strip search were actually lost their family members. So in a great situation of stress, distress, and the court could not find any justification for such treatment of the applicants. Moreover, notice that it was a degrading treatment, even more taking into account the situation in which the applicants were, so that they just survived the shipwreck and they lost their family members in this accident. So a violation of Article 3 was also found in this case. So let's move to the last case concerning pushbacks. That's the newest case. It's only 20 days old, and it concerns Hungarian-Serbian border. There, two brothers, Syrian nationals, were being smuggled with other migrants to Hungarian border through the river in the boat. Smugglers left them in the reeds near the Hungarian border and just swam away. Migrants have been hiding in those reeds for some time, but they were spotted by Hungarian officers who started to shout, "Go back to Serbia," and according to the migrants also, who used tear gas, stones, dogs to just scare them away. The two brothers decided to swim back to Serbia, and unfortunately, the applicant's brother drowned. The applicant alleged that no effective investigation had been carried out in his brother's death and into the ill treatment that he had to suffer. Also, he claimed that Hungary was responsible for the death of his brother and that he was subjected to inhuman treatment. So the court first assessed the procedural aspect under Article 2 and 3 together, as the court has said, in the light of the converging principles deriving from both these provisions. First, the court noticed that the criminal investigation that followed the drowning was of limited scope. It focused only on the use of force, whether it was used or not. Disregarded all the other elements of the police operation and did not provide any assessment of the responsibility for failing to protect the right to life. In fact, Hungarian investigating authorities did not question the police officer's statements at all, despite that migrants had provided contrary statements with regard to the course of action and the actions of the police officers, while those third country nationals mostly left Hungary before they could be once again interviewed. National authorities did not decide to follow any other options to resolve the factual contradictions. They just decided that they will believe police officers. What's also interesting that it was clear from all the statements that there were other police officers at the scene, but they were not even identified in the national proceedings. So according to the court, the Hungarian authorities did not deploy reasonable efforts to gather the evidence and establish the facts in this case. And for this reason, violation of Article 2 and 3 in their procedural aspect has been found. With regard to the substantive limbs of those articles, the court first stated that it is impossible to determine whether Hungarian authorities did use force or not. But there are many other aspects of the case that are not so controversial and that enabled the court to decide on Article 2, its substantively. So first, the court noticed that Hungarian authorities knew that that river is dangerous and that it is used by migrants to come to Hungary. They should be even more aware of that and more prepared for that, concerning that the situation at hand happened in 2016. So in the middle of the refugee crisis, and so they should expect that more people will be coming and using even dangerous pathways of entry. Moreover, the police officers near the border, they knew that migrants hid in the water. They were at risk of hypothermia, and making them to return was even more dangerous. The court then referred to Safi judgment and said that reminded that state positive obligations as regards the protection of life extend to the planning and control of the operation to ensure that any risk to life is minimized. involves an obligation to take preventive operational measures to avoid an immediate risk to life. And here, in this particular situation, no operational plan was developed for the purpose of dealing with search and rescue situation that could occur near the river. Also, there was no clear order of priorities or course of action. So basically, there was chaos when this situation happened. So the court concluded that by the failure to act rapidly and decisively, the authorities involved did not take the operational measures within the scope of the powers which judged reasonably might have been expected to protect the applicant's brother's life. Article 2 has been again found to be violated. However, there was no violation of Article 3 in this case. The applicant did rely on the use of force by the Hungarian officers, and that was the court was not able to conclude beyond reasonable doubt that the physical force was actually used against the applicant. So that would be all about the pushbacks. Let's move on to the detention and reception. There is one very interesting case, recent case from January this year against Croatia. That concerns fire in the detention facility. The applicant was a Moroccan national. He entered Croatia hidden in a truck with 3 other migrants. They were discovered and detained for expulsion purposes. Detainees started a fire, and in consequence, 3 of them died. The applicant had severe burns all over his body. He had to go through 3 operations before he was released from the hospital. So before the European Court of Human Rights, the applicant complained that the state, Croatia, had been responsible for not preventing the fire in the detention center, as a result of which he had suffered severe life-threatening injuries. And there was no effective investigation in that respect. So here the court started its assessment with the substantive limb of Article 2 and stated that first, it is not needed that the person actually dies for Article 2 to be invoked before the court and found to be violated. Then the court noticed that the police officers in this detention facility were negligent. They did not search enough the detainees. It was obvious that they had some lighter. They were smoking cigarettes in their cell. Well, the monitoring of the detainees was flawed. The police officer who was supposed to sit near the cell just went away. And the other who was supposed to look on cameras noticed that something is wrong with the camera, but thought it was some systemic problem he had with the system. In fact, it was the detainees just covering the camera and then starting a fire. The police station building was ill-prepared for a fire. And for all those reasons, the court decided that the applicant was not provided with sufficient and reasonable protection of his life and limb as required under Article 2. With regard to the investigation followed after the fire, the court noticed that the applicant, Croatian authorities promptly reacted at the beginning, took some steps to investigate what happened, but eventually no criminal proceedings were initiated, only some disciplinary ones. And many questions actually were left unanswered. And as and as noted by the court, in particular, more comprehensive question of whether there had been any broader institutional shortcomings or errors which allowed for the tragic accident to occur was not dealt with. And the court again reminded that sometimes lives are lost as a result of failures in the overall system rather than individual error. And it seems that in this case, the court noticed this overall failure in the system. And for this reason, found violation of Article 2 in its procedural limit. There is one case concerning reception of asylum seekers, which I think it's worth our attention. It's not decided yet. It has been communicated in 2021. It concerns two brothers, unaccompanied minors from Afghanistan who came to Sweden to seek asylum. When the older brother turned 18, he was separated from the applicant, his younger brother, and made to move several hundred kilometers away from him to live in some reception facility. He was suffering some mental problems already back then. And when the asylum applications were rejected, expulsion orders were issued, the older brother committed suicide. What is, I think, important and sadly interesting in this case is that the decisions issued in the case of two brothers directly mentioned that there is no risk for the older brother in Afghanistan, but the younger brother would be at risk, but he will not be at risk because he will be traveling with his older brother. When the brother committed suicide, the circumstances has changed and Swedish authorities did give protection to the younger brother. So the younger brother complains to the European Court of Human Rights that the Swedish authorities failed to protect his brother's life, his brother from committing a suicide. I think it will be very interesting to see how the court decides on that case in future. So let's finish with the protection against refoulement, the issue already introduced by Professor Turkovic. Actually, very rarely, exceptionally, in the asylum cases decided by the European Court of Human Rights, the court finds violation of Article 2 of the Convention, next to Article 3. Recently, there were two such cases. That would be one against Bulgaria and second against Russia. And let's take a quick look on them. MA and others versus Bulgaria concerned Muslim Uyghurs suspected of terrorists in China. They came to Bulgaria, they were arrested, refused asylum, and then their expulsion was ordered due to national security reasons. The applicants complained that if returned to China, they would face persecution, inhuman treatment, and arbitrary detention, and could be even executed. The court in this case noticed that the issues raised by the applicants are indissociable, thus there must be examined together. Of course, any issues connected with the national security were not important, as court many times said in the non-refoulement context. What is important if there is a real risk that the applicants will face ill treatment or death upon return to China. And here the court analyzed the situation in China, in re-education camps that have been created for Uyghurs, noticed that there are reports concerning ill treatment, torture, and killings in those camps. Also, that death penalty can be actually ordered towards Uyghurs. There have been reports of that. So for this reason, the court found that there is a real risk of arbitrary detention, imprisonment, as well as ill treatment or even death for applicants if they were removed to China. And for this reason, the court found violation of Article 2 and 3. If the second case concerns a more general context, the context of war in Syria, Syrian nationals were ordered to leave Russia, and court again reminded here that in a non-refoulement context, there must be assessment of ex officio assessment when there is a well-known general risk, and the situation in Syria is well-known for sure. After analyzing again, as in previous decisions concerning returns to Syria, the situation in Syria, the court concluded that the forced returns of refugees to Syria do not appear feasible owing to the volatile security situation there. The court also noticed that this conclusion is, in fact, strengthened by the individual characteristics of the applicants. The court noticed that there are reports of ill treatment and killings of returnees to Syria. Noticed the situation of Kurds in Syria, how anti-government persons associated with anti-government opposition are treated in Syria, or just persons who are not sharing extremist ideology. And also noticed risks, as all the applicants were young men, that they will be forced to join the army. So for all those reasons, a violation of Article 2 and 3 has been found in this case. And I would like to finish with the Polish-Belarusian border. As I started, there are already 3 cases communicated before the European Court of Human Rights against Poland concerning the situation at this border. 2 of them invoke Article 2 violation. One is, they concern 5 Syrian and 2 Afghan nationals. They were stranded in the border forest area without food, water, or shelter, and in harsh weather conditions. They suffered violence from Belarusian officers. One of them was pushed back from the hospital, Polish hospital, back to Belarus, and there was others did not have access to the medical assistance that they needed. So in those circumstances, the applicants complained that Polish authorities failed to undertake necessary measures to protect lives and contributed to a situation which put the applicant's life and health at risk. I'm waiting for those judgments impatiently, concerning that there are more and more bodies found every week at the Polish-Belarusian border. But it will be interesting whether the Article 2 actually will be taken into account by the court, or the court will focus in those cases on Article 3, which the court usually does in non-refoulement context. And maybe being mindful of time, I will finish with that and leave some room for discussion. So I'm open to take your question. I'm also curious, what do you think about those judgments? Whether the position of the court is strong enough to protect migrants' lives, especially at our borders. Thank you very much.